Hello everyone, a very good evening to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in which we are going to start the mini marathon of your BRBL subject. So as you can easily see that today we are going to do a mini marathon of module D. So you already know that in module B there are total 9 acts and module C and D are very important acts. If you want to crack this exam in a very simple way, easy way, so these two acts are the scoring act. Okay, so total 19 act you have to study in module D and module C. And guys, in June session at every Saturday your exam will be there. Okay, at every Saturday your exam will be, sorry, your marathon will be there. That is a mini marathon. So we have a 4 module, okay, and we have a 4 Saturday. So at every Saturday your session will be there. Okay, so this is very important for the examination point of view. Now guys, let's start with the question and answer session. First of all, before starting this session, I would like to say you that this is your CAIIB case study plus power pack revision batch. If you want a quick revision, okay, if you want a quick revision for the July exam 2024, so this batch is a perfect batch in which we are going to start the case studies and the revision batch. Okay, so we know that in your BRBL exam there are so many, there are so many questions that's come in the exam, just like your one-liner question, case studies question, paragraph question. So case studies questions are very important in the BRBL, which is totally based on the concept. So how to solve the case studies question in this batch we will teach you, and it's a quick revision in which we will just do a quick revision of module A, B, C, D, so that it can be easily for you to just crack the exam in the single and the first attempt. Okay, so I hope so my voice is audible to all of you, right? So now let's start with the session. Number one question on the screen, that a person in respect of whose default the guarantee is given, it is called what? It's a principal debtor, principal creditor, principal surety, or principal bailee. So guys, as we know that this topic is of your contract of guarantee, that is section 126. Okay, so contract of guarantee, what is contract of guarantee exactly? It is basically, see, no, Ranjan Sharma sir, in the last Saturday no marathon. This is the first mini marathon of your BRBL subject. So guys, in the contract of guarantee, okay, this is your principal debtor who will take money from the creditor, and this is your surety. Suppose if principal debtor is not able to pay the money, the surety will come into picture. Is that okay? Now see, a person in respect of whose default the guarantee is given, it is called what? Principal debtor, principal creditor, principal surety, and principal bailee. That is so important question and very important. So Roop Das ma'am, Choti Priyanka ma'am, you people say the principal debtor. You are absolutely right. Okay. So in this question, you can easily learn section 126. That's talk about contract of guarantee. And guys, in this session, I've just put every type of question. So that's why you have to do each and every question very carefully. Okay. That's great. Next question. Which type of guarantee is given for a series of transactions? It is called journal guarantee, implied guarantee, continuous guarantee, journal and continuous guarantee. What is the right answer? Second one. Each Saturday, your exam, your mini marathon will be there. So in June session, in June month, we will do 4 mini marathon. In July, we will do mega marathon. In July also, we will do the special session for the BRBL subject. Yes, tell me class. See, in the contract of guarantee, Rajan sir, there are two types of guarantee. Specific guarantee and your journal, this one, continuous guarantee. So special guarantee, that is for the specific purpose, okay? And in the series of transaction, that is called the continuous guarantee. So that's why for the second one, C will be the right answer. Excellent. Okay, C will be the right answer for this question. Next one. Liability of the surety is what? It is secondary liability, primary liability, subsidiary, or co-related liability. Liability means you can say Who is responsible? Liability means who is responsible. So tell me what will be the right answer. See guys, in your particular module D, your Contract Act is important, Company Act is important, Partnership, and your this one TP Act. Okay, so these are the 4 acts which is very important for the examination point of view. So now tell me class, the liability of the surety is basically of secondary liability. Why it is secondary? Secondary, why? Because see, the first liability is of your principal debtor. Okay, because principal debtor, first of all, he have to pay money to the creditor. If he is not able to pay the money, then only the surety will come into picture. So that's why for this question, A will be the right answer. Next, whose consent is necessary in the contract of guarantee? Tell me, whose consent is necessary? That is important. Whose consent is necessary? And from each act I have taken the question. The contract is very important. That's why I have taken so many questions. Tell me, what will be the right answer for this question? Tell me, what will be the right answer? The consent is necessary in the contract of guarantee. Excellent, Choti Priyanka ma'am. The right answer will be surety, creditor, debtor. D is the right answer. That's great, guys. Okay, next one. In the case of co-sureties, release of one surety by the creditor amounts to discharge of other surety, does not amount to discharge of other surety, amount to discharge of the surety, so release the co-surety and none of the above. And what is co-surety? That is so simple. This is your principal debtor, creditor, surety 1, surety 2, surety 3. So these 3 will be called as a co-surety. Is that okay? These 3 will be called as a co-surety. So guys, in the case of co-surety, the release of one surety by the creditor, what is the right answer for the 5th one? And do not forget to like and subscribe the channel of Officer Adda. That is very important. The right answer will be excellent. Suppose if the one surety will be discharged, it will not discharge the other surety because each surety have a different liability. So that's why. So for the 5th one, B is the right answer. That's great, guys. Okay, next one. What is called bailment, class? And first of all, bailment, you have to learn the section, that is section 148. This is called bailment. So bailment means a delivery of a thing entrusted upon some specific purpose and object upon a contract. B, delivery of goods free of cost. C, delivery of goods without cost for the welfare of public, and none of the above. What is the right answer? The term bailment. This is very simple question. The term bailment means what? So guys, the term bailment means basically the delivery of thing entrusted. Entrusted means to just give for a specific purpose upon the contract. Suppose if I'm just parking my car for 3 hours, and after 3 hours, if I'm just taking back my car, it is called what? That is called bailment. Okay, so for the 6th one, A is the right answer. Next question. In a pledge contract, what is bailee? See class, in every special types of contract, each party have a name. So in the pledge, what will be the name of the party in the bailee? Tell me class. Tell me class, what will be the right answer? That is easy one. In the bailment, Bailor and bailee is there. Okay, in the pledge, if we call bailee, so that is called as a bounty. So guys, 7th one, B is the right answer. Okay, next. The bailment of good as security for the payment of debt or performance of promise is called what? Pledge, bailment, contingent contract, or agreement. What is the right answer? What is the right answer? Yes, class. Tell me. The bailment of good as security for the payment of debt, it is called, and the performance of promise is called what? Pledge, bailment, contingent contract, or agreement. The right, it's not contingent contract, Baba. This is the bailment as security. So suppose if we have taken 10 lakh loan from the bank and we are giving the movable property as a security, this is called pledge, no? So eighth one, A is the right answer. That is so easy. A is the right answer for this question. Okay, next one. The bailor is bound to disclose to the bailee fault the goods, price of goods, weight of goods, and owner of goods. What is the right answer? Yes, class. What will be the right answer for this question? Yes, Priyanka, Kumari ma'am, Makeshwar sir. How are you? Rupdas ma'am, Triveni, Botu sir ma'am. The bailor is bound to disclose the bailee the fault in the goods. So the ninth one, A will be the right answer. Is that okay? That's great. Next one. When no consideration passes between bailor and bailee, it is called what? No consideration. So what is consideration? The consideration is basically something for something. Consideration is basically something for something. So guys, non-gratuitous bailment, gratuitous bailment, spatial bailment, and the conditional bailment. What will be the right answer? Absolutely, Makeshwar sir, I'm absolutely fine. So guys, tell me, when no consideration, because we know that for the valid contract, we need a consideration. So if no consideration passes between bailor and bailee, it is called what? Tell me. That is so simple. It's a non-gratuitous bailment. Gratuitous, no consideration. So guys, if the no consideration is there, it is called gratuitous bailment. Suppose if I am giving anything to my friend, if I'm giving my book to my friend, that is called gratuitous bailment. So for the 10th one, B is the right answer. Okay, ma'am, non-gratuitous bailment means in which we just need a consideration. We just need a consideration, that is called non-gratuitous bailment. So A is the right answer. Okay, for 10th one, B is the right answer. And for the non-gratuitous, I have just told you the meaning. It is in which the consideration is there. Okay, consideration is there. Okay, now next one. A gives B 2 suitcases to store for him when he is at meeting. Okay, what is the correct relationship between A and B? Tell me, class. A give B 2 suitcases. That is good question. And the question in which you are giving the wrong reply now, so please revise it. Okay, please revise it. Yeah, what is the right answer? A gives B 2 suitcases to store for him while he is at meeting. So what is the correct relationship between A and B? Tell me, what is the right answer? What is the right answer? That is so simple. That is so simple, guys. Today, Roop ma'am, we will also do the paragraph based question, case studies questions. So many questions today we have to do. Every types of question, that will come in this one. So class, for the 11th one, if A gives B 2 suitcases, so A is bailor and B is bailee. So for 11th one, B is the right answer. Excellent. Next one. Okay, this is your case studies question. This is your case study question, and that is a very famous question. Okay, now what happened in this case? Lalu is going to Ayodhya for a pilgrimage. He left his cow Dudheru with his neighbor Meera in consideration that she could sell the milk as long as she had the cow. After he left, the price of the milk shot up due to the heavy seasonal demand. Meantime, the cow got pregnant. the cow deliver a healthy calf that is called Kandheru by Meera. When Lalu returned, he asks back for the cow, the calf, and the part of profit. So guys, three things he just demand. The first is cow, then the calf, then the part of the profit. So now you have to tell me what thing Lalu can take. So there are six options and you have to tick mark which one is the right one. Okay, which one is the right one? Tell me. Which one will be the right one? That is very good question, very important question. Tell me, class. This is the example of bailment. This is the example of bailment, guys. Tell me what is the right answer. So this is very important question. First of all, Lalu will take his calf, but not part of the profit because there is a no particular profit regarding anything written in the fact. So the cow and the calf he can take. So not entitled. Entitled to make profit? No. Lalu is not entitled to cow? No. Lalu is entitled. The 4-1 is right. The 4-1 is right. So it means C can be answered, D can be answered. Lalu is not entitled to calf. This is wrong. Lalu is entitled to calf. Exactly. So first and sixth. So first and sixth. So the right answer will be D will be the right answer. D will be the right answer. No, Ganesh sir. D will be the right answer. He will not take profit because there is a no discussion of profit in this particular case. Okay, so this is very much important case. So for the 12th one, D is the right answer. So Lalu will take his calf, that's it. Okay, so D is the right answer. Done, guys. Next one. Okay, class, now you have to tell me the section. You have to tell me the section of valid contract, indemnity, guarantee, bailment, pledge, and agency. Very important concept. If you have any doubt, you can please ask in a comment box or you can ask the question here. Tell me. Section based question always come 3 to 4. Tell me, class, section based question. Tell me the section of valid contract, indemnity, guarantee, bailment, pledge, and agency. Tell me, what is the right answer? That is so simple question. This is called section based question. The section based question also come in your exam. The section based question also come in your exam. So valid contract, for the valid contract, the section is 10. Indemnity section is 124. These are the important sections. Okay, guys, important sections. Done. Contract of guarantee 126, bailment 148, pledge 172, agency 182. So guys, these are the important what sections. I'm not saying that you have to learn all the section that we have discussed in the paid class, no, but at least you have to learn the important sections that we have read in the class. That's it. Is that clear, guys? Is that clear? Excellent, Ganesh sir. Excellent. Excellent. So these are the important, this one. Okay. Next one. Okay. This is very much important. What is this? See, the first one is minimum number of member in private and public company. Maximum number of member in private and public company. Maximum number of member in one person company. Okay. Maximum and number of member in LLP. Maximum minimum number in partnership. This is very, very much important question. Tell me the right answer. Tell me the right answer for this question. Yes, class. That is a good question. I think it's a quick revision of how many members, partners are there in this one. Excellent, Priyanka ma'am. Excellent. Just give me a quick reply. So guys, if we talk about the minimum number of member in private company, minimum, that is 2, and for public, this is member, that is 7. Maximum number in private, 200, for public, that is unlimited. Minimum and maximum number in one person company, minimum 1, maximum 1. LLP, minimum 2, maximum unlimited. Maximum minimum number in partnership, that is 2 and that is 50. Please read all the answers. That is very, very much important. Minimum number of director in private and public company. So for the private, minimum is 2. For the public, minimum is 3. We are talking about the director. Maximum number of director in public and private, that is 15. That is 15. Minimum number of director in one person company, minimum is 1 and maximum is 15. Maximum can also be 15. So minimum and maximum number of directors in this one. So I think this concept is clear to all of you. Any doubt, class? Any doubt? Any doubt? I think this is one of the best thing to remember, because in your without option questions now, in the without options, these types of questions will become. Okay, in without options, these types of questions will become. Is that okay? So I think this is clear to all of you. Let's move toward the next one. Okay, let's move toward the next one. Next. When minor who was admitted to the benefit of partnership become a major upon attaining the age of majority, so his personal liability commences from, tell me, his personal liability commences from what? So class, just remember section 13 that we have discussed. Just remember section 30 that we have discussed. So what was section 30? What was section 30? So section 30 is basically, suppose if X is a minor, right? He become major. So when he become major, he have a 6 month of time to declare himself whether he want to become a member, this one partner, or whether he not to become the partner. If we suppose want to become a partner, so in this case his liability will be start from the date of his first admission to the benefit of partnership. So guys, A will be the right answer. Is that okay? A will be the right answer for this question. Excellent. Okay, next. Where a partnership firm is constituted for a fixed period, we know the types of partnership. After the expiration of the term, the firm continue to carry business without any agreement. So such partnerships stand extended. The partnership will become at will. The partnership become illegal, and the partnership stand dissolved on date of expiry of the term, and no partnership can be still in existence. What is the right answer? What is the right answer? And class, your power pack revision batch is already in the store. If you want to purchase, you have to apply the coupon code Y391P. Sorry, Y391. When a partnership firm is constituted a fixed period after the expiration of the term, the firm continue to carry business without any agreement. The firm is continue to carry the business. So guys, if the firm is continue to carry the business, the partnership will become partnership at will. So for the 14th one, B is the right answer. Okay, B will be the right answer for this question. Is that okay? Now, next one. A warranty is a stipulation dash to the main purpose of contract, the breach of which give rise to claim for damages but not right to reject the goods. Guys, this question already came in your exam in 2023 batch. In 2023 batch, this question already comes. So what will be the right answer? The definition of condition and definition of warranty, that is very, very much important. Tell me. A warranty is a stipulation dash to the main purpose of contract, the breach of which give rise to claim damages but not to right to reject the goods. So for this one, warranty, please remember the word that is written in the definition, because as it is, definition will be asked. So for the 15th one, B is the right answer. 15th one, B will be the right answer for this question. Is that okay? Next, and if it is condition, so in condition, the stipulation is the essential point. So for 15th one, B is the right answer. Next, a lien can be exercised by unpaid seller only. Lien means to hold the goods. So guys, the lien can be exercised by the unpaid seller only when the ownership right relating to goods have transferred to the buyer, when the goods are still in the possession of unpaid seller, when the goods have been transported through the carrier made available to buyer, and when the goods have delivered to the buyer. So what will be the right answer? Tell me, class. A lien can be exercised by the unpaid seller only when the goods are still in the possession of unpaid seller. So for the 16th one, B is absolutely the right answer. Next, what is Tarkan rule is related to doctrine of ultra vires, constructive notice, indoor management, subrogation. So first of all, let me explain each doctrine. Ultra vires means beyond the power. You cannot do anything. Constructive notice means that the company is not liable if the investor have not seen the clauses of document. Indoor management, that is basically if company is changing anything, that thing they have to inform. If they are not informing to the investor, the company is liable. And subrogation, if principal debtor have paid the money, sorry, in the case of principal debtor, if surety have paid the money to creditor, now surety can demand money from the principal debtor. That is called subrogation. So Turkan rule is related to what? Turkan rule. Exactly, Roop ma'am. So guys, the Turkan rule is related to the indoor management. So 17C is the right answer. A company being a legal person is also citizen under the consti. That is true, false, or partially true and partially false. Tell me, class, what is the answer of 18th one? A company, as we know that the company have a different legal existence and the member have a different legal existence. So company being a legal person is also citizen under consti. This is absolutely true. So for the 18th one, A is the right answer. That is true. Okay, that is true. Citizen means artificial. It's a legal person. Citizen, it means artificial legal person. It's a artificial legal person. So this is the right one. 18th one, A is the right answer. Okay, it's artificial legal person. Next, which of the following mortgage can be made without writing? Tell me, class. Which kind of mortgage can be made without writing? Equitable, English mortgage, simple mortgage, or usufructuary mortgage? What is the right answer? What is the right answer for this question? So class, in the TP Act group, ma'am, we have just seen the various types of mortgage. The mortgage which is without registration, the answer will be equitable mortgage. When I was just teaching you the module D, you people were asking, ma'am, just give me the example of types of modules. So the examples are same, only the essential points are different. So in the 19 one, it is basically only equitable mortgage is there, that is made without writing. Why? Because if the customer, if any person is depositing the title deed, that itself is a what? Document. So for the 19th one, A is the right answer. Ah, Baba, that is very simple. That is very simple. That is made without writing. It is equitable mortgage. This is so simple, Baba. Don't give me wrong reply. Okay. Next, where principal money is secured 100 rupees and upward, the mortgage other than mortgage by deposit of title deed can be affected only. It means the options is not for mortgage by deposit of title deed. Tell me the right answer. Tell me for the 20, what is the right answer? Where principal money secured is 100 rupees and upward, the mortgage other than mortgage by deposit of title deed can be affected only by the excellent. The right answer will be by registered instrument signed by the mortgager, attested by at least 2 witness person. So for the 21, D is the right answer. Okay, next one. IT Act amended various section of which of the following act? IPC, Reserve Bank of India, Indian Evidence Act, Bankers Book Evidence Act, and all of the above. So guys, when IT Act will come into picture, this thing we have already done. This thing we have already done. Tell me the right answer. Tell me the right answer for this question. Yes, class. When IT Act come into picture in India, okay, so guys, 4 Act has been amended. What are the 4 Act? You can see the 4 Act. That is IPC, Reserve Bank, Indian Evidence. This is so D is the right answer. Next. Which of the following is true about the designated partner required in LLP? LLP can have at least 2 designated partners. This is absolutely true. LLP can have at least 3. No. 7. No. 4. No. The correct answer is A is the right answer. A will be the right answer for this question. That is so easy. Okay, that is so much easy. Next, see class, this is your definition part. Okay, the public servant under Prevention of Corruption Act means what? Any person in the service or pay of government and remunerated by government by the fees and commission for the performance of any public duty. Any person in the service and the pay of local authority. Any person in the service and pay of a corporation established by or under central, provincial, state act. What? So what is public servant in your opinion? What is public servant under the Prevention of Corruption Act? So guys, in the public servant there are so many points. Tell me the right answer. So the public servant under Prevention of Corruption Act is basically a very good question. Excellent, Triveni, Bodu sir, Choti Priyanka ma'am. D is the right answer. Okay, guys. Oh my God. Now, class, a case study. No, it's a paragraph based question. Okay. So, guys, the paragraph is there. Okay. And you have to tell me the answer of 5 questions. And the 5 questions belong to that paragraph. Okay. Let's start the session. That is very important. Okay. Now, see. Any agreement between two and more parties that is enforceable by law, that is called contract. So, guys, this is the definition of contract. Okay. In India, contract is governed by Indian Contract Act 1872, which is a statute containing detailed provision on the various aspects of contract, including execution and enforcement. Okay, section 2H, please learn that section, which define the contract. So it is an agreement enforceable by law. So we have already done the definition of contract. Offer plus acceptance is equal to promise. Promise in legal term is called agreement. In agreement, when law will be enforced, that is called contract. So this is the formula of contract that we have discussed in the page class. Okay, guys. Now, so we have done the definition of contract and agreement. The formation of agreement is necessary for a contract to come into existence. So this is your first paragraph. Any doubt in the first paragraph? Any doubt in the first paragraph? I think that is easy for you because we have already done Indian Contract Act. Section 2E talks about agreement, the definition of agreement. So guys, the definition of agreement, that's talk about every promise, every set of promises forming the consideration for each other. It is an agreement. The formation of agreement take place when the offer is made by one party and accepted by another. As we know that if a contract is there, so offer is accepted and the consideration is there, then is equal to contract. So under Indian Contract Act, an offer is termed as proposal. Okay, offer is also called proposal. If there is no proposal at all, if a proposal has been made but not accepted, agreement will not come into existence. Exactly, if you are making an offer is not accepted, the agreement will not make. Indian contract regulate various aspects of offer and acceptance, such as manner of making offer acceptance. When communication of offer acceptance get completed, the condition of valid acceptance. That is so much easy. Any doubt, class, in this paragraph, Ganesh sir? Any doubt? This is your paragraph based question. So at least 2 paragraph based question will become, in which in each paragraph the 5 questions will be there. Any doubt, class? Tell me any doubt in this paragraph. Any doubt? Okay. Next. Section 2A talks about the proposal. Section 2A talks about the proposal. When one person signifies to another his willingness to do and to abstain from doing anything with a view to obtaining the assent of other to such act and abstinent, that is called proposal. So class, the definition of the terms are now little bit difficult, but when you understand the definition in an easy concept, then you can relate each word very carefully. So guys, in the yellow highlight, the sentence which I have highlighted, Priyanka ma'am, that is the, definition of what? Proposal. And what is proposal? That is an offer. Thus, offer, proposal essentially indicate the person will. Exactly, if someone is offering, it means the person willingness is there, right? Promiser, the person who make promise. That's it. Okay. A party may communicate. What is this? A party may communicate a proposal by doing act and omission by which he intend to communicate such proposal to the effect of communicating. Section 4 explain when the communication of proposal get completed. So guys, the offer will be get completed when it come to the knowledge of person to whom we are making the proposal. Okay, this is your this sentence. See what is given here. The communication of proposal gets completed when the proposal come into the knowledge of person to whom it is made. So this is the right answer. Indian contract also talk about revocation of offer. If Nikita ma'am offer, now she want to revoke the offer. Revoke means to taken back the offer. Okay, so there are 6 particular points in which we can just revoke the offer. See, if we just give notice, lapse of time, by failure of acceptor to fulfill the condition, by death and insanity. So guys, these are the 4 points in which we can just revoke our offer. It is important to know that offer is different from invitation to offer. Exactly. Offer is different class and invitation to offer is different. Invitation to offer, just like the sale, tender, auction, that is called invitation to offer. And offer, the final willingness. So you have to learn these things. You have to learn these things. Exactly, Chotu Priyanka ma'am. Yes. This is called paragraph based question. This is your, see ma'am, if you know the concept now, Choti Priyanka ma'am, only 2 or 1 paragraph will come and 5 question. Just see the question ma'am, then you will enjoy the session. Choti Priyanka ma'am, just see the question. Then you will not say ma'am, itna lengthy question aata hai kya? You will never say this line. Okay, just see the question. I think that is clear to all of you. Shall I start the question? Tell me. Shall I start the question? The questions are damn easy. And question is totally related to this one. Questions are damn easy. Tell me. Is that okay? Done? Okay, let's start the question. Then you will enjoy. Okay, ma'am. First question. See. The first question is, if A goes to stationery shop, picks up pen and places a note of ₹10 in front of the shopkeeper while pointing to the pen and holding it up his hand without saying anything, A's conduct may be interpreted to mean that A has made what to the purchase of the pen? Tell me the right answer of first one. That is easy one. That is the easy one. Don't say me, ma'am. This is so much lengthy question. No. This is a very simple question. Now you can easily say, Choti Priyanka ma'am, oh my god ma'am, this is so much easy question. Okay, so don't be afraid of this one. Okay, don't be afraid. Okay, so the right answer will be, this is basically, it is an all call offer. So for the first one, D is the right answer. It's not invitation. This is so simple question. Just see what the question is saying. A goes to stationery shop, pick up a pen and places a note of ₹10 in front of the shopkeeper while pointing to the pen and holding it up in his hand without saying anything. A's conduct may be interpreted, that is called offer. Okay, so A has made an offer. A has made, it is not, why you are saying invitation? A has made an offer because the shopkeeper have already accepted. That is written now. So D is the right answer of this question. Next. A send a letter by post to B containing offer. The communication of such offer shall get completed only when the letter has been received and read by A. Why it is so? Tell me class, why it is so? What will be the right answer for this question? How? Roop ma'am, that is so simple question. See ma'am, what is given here? A goes to stationery shop. Suppose Nikita ma'am go to stationery shop. She pick up the pen and place a note of rupees 10 in front of the shopkeeper while pointing out the pen and holding it in that without saying anything. So A's conduct may be interpreted means A has made an offer. Exactly. Ma'am, if the shopkeep in the shop na, in the shop everything is invitation to offer. But if I have just pick anything na, that is called offer. Okay. The things which is in the display, the goods which are in display of the shop, that is called invitation to offer. Is that okay? So this is the right answer. Second one, the offer has not come yet to the knowledge of this. Why class? A send letter by post to B containing offer. The communication of such offer shall get completed only when the letter has been received and read by B. That is so simple question, guys. That is so simple. See class, in this particular case, that is already done. Okay, so that's why none of the above is there, because the offer is completed, because that is letter is received and read by the B. So that's why the offer is completed. The communication, and you can say there is a completion of communication of offer. That's it. So D is the right answer. Next, if A made offer to B and before accepting the offer, B finds out that A is proved insane person, so what shall happen to the offer? Tell me. That is important. What shall happen to the offer? The offer will be renegotiated. A's insanity will scare B to accept the offer. The offer will stand revoked and the offer may be passed on to the another party. Tell me class, what is the right answer? Tell me. And each Saturday be ready with her modules. Okay, so today we have done module D. After next Saturday, C, then B, then A. A is clinically proved insane person. So guys, if he's insane person, the offer is revoked. So third one, C is the right answer. The display in the goods by the shopkeeper in his shop, it is called what? Tell me, it is called what? Invitation to make offer, a contract, proposal, and sale. So guys, display of the goods. So display is basically invitation to make an offer. So fourth one, A is the right answer. So class, that's all for today's class, and I hope so you people like the session. And see class, this is your power pack revision batch in which I will teach you the case studies question and the power pack revision batch. Okay, so this is basically you have to apply the coupon code Y391 for the maximum discount. Okay, in the power pack revision batch there will be the revision of all the modules in the one slide. So that is very, very much important, and there are elective paper also. So guys, if you want to crack this exam, okay, if you want to crack this paper, So do not forget to purchase this batch. For this thing, click on adda247.com. Okay. After that, all courses, you have to click on all courses. Then CAIIB CAIIB, this is June 2024, and this is your Power Pack batch. It's a English medium batch. Click on buy now. Apply the coupon code Y391. If you click on apply, you can see 79% discount is there. 79%. So this particular revision batch is only of 3,359. So if you want to crack this exam, apply this coupon code and do not forget to purchase this session. That is very, very much important. Thank you so much, ma'am and sir. So next Saturday, be ready with the module C. Okay, next Saturday, I will just tell you the time before the paper. Okay, so thank you so much for attending the session. Thank you, guys.